Hey guys, today I'm going to talk about the offence of child molestation in Singapore and the sentencing framework. Now, if you are offended or are not comfortable with this topic, you might want to turn off this video and watch some other things now. In 2021, I defended a 74-year-old gardener who molested a 7-year-old boy. Well, if you want to know more about the facts of the cases, you can Google the keywords I just mentioned and read up about the facts of the case. In Singapore, the penal code, which governs most of the criminal acts, contain a section called 354, which is called outrage of modesty. Outrage of modesty simply refers to molest, and section 354, subsection 1, refers to assault or use of criminal force to a person with intent to outrage modesty. Section 3541 is for adults. Section 3542, Section 354 subsection 2 is for children, and it provides that whoever assaults or uses criminal force to any person below the age of 14 years intending to outrage or knowing it to be likely that he will thereby outrage the modesty of that person shall be punished with imprisonment for a term which may extend to 5 years or with a fine or with caning or with a combination of such punishments. To understand how accused persons are sentenced under section 354 subsection 2, in other words child molest, we have to look at the seminal case of GBR and public prosecutor, where the High Court laid down the sentencing framework for sentencing people accused of child molestation of children who are below 14 years of age. In GBR, the accused claimed trial to one charge under section 3542 for fondling his 13-year-old niece's breasts and touching and licking her vagina area. His defense was that of bare denial. He said, no, I didn't do it. In particular, he insinuated that the victim had a purported motives for making false allegations against him, and that the victim did not react like a typical victim of a sexual crime during and after the alleged offense. He said, for example, that she did not scream, shout, or cry for help. The district judge in that case convicted the accused of the charge and sentenced him to 21 months imprisonment and 4 strokes of the cane. On appeal, he was sentenced to 25 months and 4 strokes of the cane. The case of GBR laid down the sentencing framework for such offences. Stage 1, the degree of sexual exploitation. These include the part of the victim's body that the accused touched, how the accused touched the victim, and the duration of the molest. The offence is more aggravated if the victim's private parts like the penis, the vagina are touched, and there is skin-to-skin contact as opposed to touching over the clothes of the victim, and the sexual exploitation continued for a sustained period of time rather than a fleeting moment. Once stage 1 has been established, the court will then look at stage 2. During stage 2, the court will consider the circumstances of the offence, including the presence of premeditation, whether the accused planned the molest. Number 2, whether there was any use of force or violence. Of course, if you use force and violence when molesting, you're going to get a harsher punishment. Number 3, whether there was an abuse of position of trust. This primarily concerns 2 types of cases. The first is where the accused is in a position of responsibility towards the victim. For example, parents, step-parents and their children, doctors and patients, teachers and their pupils. Obviously, in such situations, there is a position of trust. And if there's an abuse of such a position of trust, for example, a teacher molests his student, a stepfather molests his stepdaughter, this is going to be more serious. The second is where the accused is a person in whom the victim has placed her trust by virtue of his office or employment. For example, a bus driver and a school child. Deterrence is a particular concern when there is abuse of trust in a family context, since it is hard to detect and there are considerable barriers faced by the victim in reporting them in a family situation because, for example, a young girl is less likely to want to report her stepfather for molest because it will destroy the family. So there's particular concern for such cases. The fourth factor, the use of deception. In the case of public prosecutor and Al-Habib, the accused entered the victim's house by pretending to give a massage to the victim's mother, who believed that the accused had special healing powers. The accused then brought the victim, the young girl, to the kitchen toilet under the guise of removing ghosts from her body. So in the toilet, okay, after he massaged the mother, he brought the girl to the toilet. The accused touched the victim's breasts and twisted her nipples for 5 minutes. In the case of public prosecutor and Gao, the accused, who was a massage therapist, suggested to the victim that he perform a body massage on her to improve her blood circulation. In the course of the massage, the accused fondled and stroked the victim's breast, caressed her buttocks, and touched her vagina. Such acts would amount to the use of deception. The court will also consider other aggravating acts accompanying the outrage of modesty. For example, in the case of GBJ, the accused played pornography before he molested her. Another illustration of aggravating acts would be the use of sedating drugs, for example, sleeping pills, giving the victim sleeping pills, or GHB, the date rape drug, to render the victim unconscious or unable to defend herself before the molest. Another important factor that the court will consider in Stage 2 is the exploitation of vulnerable victims. The framework did not intend to treat all offences committed against minors equally. The aggravating factor of young age would, in relation to enhanced offences, apply if the victim concerned was materially younger than the stipulated age ceiling and in a graduated manner depending on how young the victim was. If the offence were, for example, perpetrated against a toddler, a kid who is 1 or 2 years old, this would be more aggravated than against an older child, like a 10-year-old child, for the reason that the toddler, the young 1-year or 2-year-old child, would be defenseless and unable to extract himself from the situation. I will also add that if the victim has certain other vulnerabilities, for example, mental or physical infirmities such as a low IQ, Down syndrome, this would further aggravate the offense. So thanks for watching this first video on the GBR sentencing framework. I will discuss more in the next video.